Good morning, students. Today we are going to deal with the advisory jurisdiction of the Inter-American Court of Human Rights. We have already covered with the, we have already covered the contentious jurisdiction of the American Court of Human Rights, and today we will be covering the advisory jurisdiction. Now, advisory jurisdiction of the American Court has been, dealt in Article 64. Okay, and Article 64 of the convention, it reads as the member states of the organization may consult. Okay, so therefore, who is empowered to to request uh, an advisory opinion from the American Court of Human Rights? It is the member states of the organization. Okay, the states who are members to the convention, they can ask or request a advisory opinion from the Court of Human Rights. Okay, so the member states of the organization may consult the court, and on what what can they ask the advisory opinions on? They can consult the court regarding the interpretation of this convention or of other treaties concerning the protection of human rights in the American states. So please pay attention that, and please remember that the advisory jurisdiction of the court is not just limited to the interpretation of the provisions of the convention. Okay, or it's not related to just the working of the convention. Okay, instead the article 64, it goes a step further. Okay, and provide enlarges the jurisdiction of the court in the sense that it also gives the states who are members of the organization, okay, to ask or request an advisory opinion from the court, okay, on other treaties that they are members of. Okay, and those treaties which are concerned with the protection of human rights. Okay, so for example, a state X, which is a member of the Organization of American States, okay, which is a member to the convention, okay, it can and it is also party to the to a treaty ABC, okay, which is for the protection of human rights. Okay, the subject matter of the treaty is the treaty deals with protection of human rights. Okay, so the state X, it can also request an advisory opinion from the Court of Human Rights. Okay, on the interpretation regarding or on the working, etc., with regard to the this treaty ABC. Okay, which of which the concerned state X is also a party, to which the concerned state is the concerned state X is also a party. Okay, so the member states, they can not only request the advisory opinion from the Court of Human Rights on the interpretation of the convention itself, but also regarding the interpretation of any other treaty which is concerned with the protection of human rights. Okay. It further says that within their spheres of competence, the organs listed in Chapter X of this Chapter 10 of the Charter of the Organization of American States, as amended by the Protocol of Buenos Aires, may in like manner consult the court. So here we again see that it is not only the member states which are empowered to request an advisory opinion, but it is also certain organs of the Organization of American States, okay, which can or which are authorized to request an advisory opinion from the Court of Human Rights. Okay, so the member states and certain organs of the organization both are empowered to request an advisory opinion from the Court of Human Rights. Okay, so in this way we find that the advisory jurisdiction of the American Court of Human Rights, it is very large and very wide. Okay, now the member states of the OS or certain inter-American organs, including the Commission, may consult the court with regard to the interpretation of the convention or other treaties relating to protection of human rights in the American states. Okay. Now, in its advisory opinion on restrictions to death penalty, okay, which concerned the interpretation of Article 4 of the American Convention of Human Rights, okay, and which was asked by the American court by invoking Article 64(1) of the American Convention on Human Rights. Okay, in this uh, case, okay, in this advisory opinion, the court observed, made certain observations with regard to its advisory jurisdiction. Okay, and it said that the advisory jurisdiction that has been conferred on the court, Inter-American Court of Human Rights, okay, under Article 64, it is unique in contemporary international law. Okay, because neither the ICJ nor the European Court of Human Rights has been granted the extensive advisory jurisdiction which the convention confers on the Inter-American Court. Why? Because in case of European Convention of Human Rights also, we have studied and we have seen that the organs are not, allow empowered to request an advisory opinion from the European Court of Human Rights. Okay, but in this case, we see that the even the organs of the American states, okay, organs of the Organization of American States, like the Commission on Human Rights, the American Commission on Human Rights. Okay, they can ask and or they can request an advisory opinion from the court. So in this way, the conventions, the advisory jurisdiction is very large, okay, and is unique in contemporary international law. Now, the court it emphasized that the convention, by permitting member states and the OAS organs, means Organization of American States okay, uh, Organization of American States organs to seek advisory opinion creates a parallel system to that provided for under Article 62 and offers an alternative judicial method of a consultative nature. Okay, now the court is telling that this enlarged advisory jurisdiction that has been conferred on the American Court of Human Rights, okay, it is uh, creating a parallel system, okay, to that established under Article 62. And Article 62 is concerned with the contentious jurisdiction. So in one we have the system of contentious uh, jurisdiction, okay, whereby the states can bring a case against another state, and here we have the parallel system of uh, advisory jurisdiction, whereby the states and the organs of the Organization of American States, they can ask an advisory opinion from the court. And the advantage of this advisory jurisdiction of the court is that it, you know, does not subject the members and the organs of uh, and the organs of the Organization of American States to formalism and sanctions, okay, that is associated with the contentious judicial process. Okay, so for example, if a case is brought under Article 62, okay, a case is brought under Article 62, and there a judgment is given or the decision is given against that state, okay, uh, is given against a state. Now the state against whom the judgment is given, because the convention is binding in nature, it will be, the state will incur, responsibility under international law for the violation of the rights that have been given under the convention, because it's a violation of the mandate of the convention. So therefore, the state will incur international responsibility. Okay. Now, this is not there in the case of advisory opinions. Okay. So a member state, if it has, you know, a doubt, okay, how with regard to the interpretation of the mandate of the convention, or interpretation regarding a provision of the convention, etc. So what it can do is, it can ask the court an advisory opinion, okay, whereby, and the court can, by its advisory opinion, it can guide that particular state, okay. And in response to this, to the advisory opinion that has been given by the court, the state can take necessary measures, necessary actions that may involve modification of its domestic law, amendment of its legislative enactments, etc., etc. Okay, so the state can take, necessary measures, so that its conduct, okay, is in conformity with the mandate of the convention, and thereby it can not be in conflict with the obligations of the conventions, and therefore incur, it will not incur international responsibility. Okay, so this is a big advantage that the advisory jurisdiction provides to the states concerned. And this goes further. Okay, it is not only the states are not only are not restricted only to the interpretation of the provisions of the convention itself or the convention. Okay, they can also ask, for an advisory opinion on any other treaty to which they are party, and which is concerned with the protection of human rights. Okay, for an interpretation of that treaty. Okay, with regard to its domestic laws. Okay, so the court, the advisory jurisdiction, it really assists and helps the states concerned in this regard. Okay, now the court, it also said that it will be inconsistent with the object and purpose of the convention and the relevant individual provisions to adopt an interpretation of Article 64 that would apply to the jurisdictional requirements of Article 62, and thus rule out its intended utility. Okay. Now, Article 62, we already know Article 62 is concerned with the contentious jurisdiction. And before, you know, a case comes to the court in contention, under the contentious jurisdiction, we know that uh, it cannot come directly to the court. It has to come by way of commission only. And there are other requirements that have to be fulfilled. For example, exhaustion of local remedies has to be there, etc., etc. So all these have to be taken care of. Okay, but these procedural requirements that are there, okay, or jurisdictional requirements that are there under Article 62, okay, they will not be applicable to Article 64. Okay, and therefore Article 64 is much more accessible and simple. Okay, the procedure under Article 64 is much more simple than that under Article 62. Now we come to some of the important advisory opinions of the court. Now, in the case of the right to information on consular assistance in the framework of the guarantee of due process of law. Okay, in this case, an advisory opinion was sought by the United Mexican States. Okay, this United Mexican States is the official name of Mexico. Okay, so in this case, Mexico sought an advisory opinion on several treaties that were concerned with the protection of human rights in the American states. Okay, and in particular, the treaty that was involved was the Vienna Convention on Consular Relations. Okay, and the issue before the court was that of minimum judicial guarantees. Okay, and the requirement of due process when a court sentences death to foreign national whom the host state has not informed of their right to communicate with and seek assistance from the consular authorities of the state of which they are nationals. Okay, so this case was concerned with the minimum judicial guarantees that have to be provided. Okay, and the requirements of due process that have to be complied with. Okay, in order that you know uh, justice can be done or justice is done with the individuals that have been detained, arrested, or after being detained and arrested they are prosecuted and convicted. Okay, there's some procedural minimum judicial guarantees. A fair procedure has to be uh, followed. Okay, and there are minimum judicial guarantees. For example, they have to be informed of the charges against them. Okay, they have to be informed on the grounds as to why they have been detained or arrested, etc. So these are minimum judicial guarantees. Okay, and in when a foreign national, is arrested, or when a foreigner is arrested in a state, okay, then in that case, when a convention on consular relations it comes into play. Okay, it governs. It has mandated certain rights which have to be which the states which are arresting or have detained that foreign national, they are obliged to respect. Okay, they have to provide the rights that have been stated under the Vienna Convention on Consular Relations. Okay, in this case what happened was that there were applicants, and some applicants they had been given death sentence in USA. Okay, and therefore therefore Mexico it sought an advisory opinion from the European Court of Human Rights. Okay, now in this case, the court it unanimously decided that Article 36 of the Vienna Convention on Consular Relations, it confers certain rights upon the detained foreign nationals. And among those rights that have been conferred, there is the right to information on consular assistance. Okay, now the court said that this right, okay, that is the right to information on consular assistance, it is obligatory on the parts of states. It is mandatory. When a foreign national is detained or arrested, the courts have to tell that foreign national have to inform him that he has the right to approach his, to take help from his embassy or consulate. Okay, to inform his embassy or consulate that he has been arrested and detained, so that they can come to his help and provide him with any help that he might be needing in his case. Okay, and the court also said that this right carries with them correlative obligations for the host state. So we already know, I had told you that rights and duties go hand in hand. Okay, if you have a right but nobody has a corresponding duty, then that right has no meaning, it's meaningless. Okay, so in order for you to enjoy a right, somebody must be under a duty. Okay, a corresponding duty to that right. Otherwise, against whom how you will exercise that right, against whom you will be exercising that right. So rights and duties go hand in hand. So in this case, if the right has been provided to the foreign nationals or to the foreigners, okay, when they have been detained or arrested, okay, that right that has been conferred uh, on the foreign nationals. It confers or it imposes a duty on the state which has arrested or detained them to provide or to respect or to give that right, okay, to or those rights to the uh, arrested or detained individuals, okay, foreign nationals. So the state is under an obligation, okay, to inform the particular person that he has the right to consular assistance. Okay, now the code it said that the Vienna Convention on Consular Relations it forms a part of international law, and it interpreted the expression without delay. Okay, which uh, is there in Article 36 1b of the Vienna Convention on Consular Relations, and interpreting this expression without delay. Okay, the because the grounds of detention or arrest, okay, of the charges against him, of his right to consular assistance, they have to be informed to the concerned individual or person who has been arrested, okay, without delay. Okay, so these rights have to be the concerned individual has to be informed of his rights, okay, without delay. So this expression without delay was interpreted by the court, and interpreting this uh, expression, the court it said that the duty to inform the that this without delay means that the duty to inform the detainee of the rights that the article confers upon him at the time of his arrest, or at least before he makes a statement before the authorities. Okay, so without delay in this case, okay, it means that the person who has been arrested or detained, he has to be informed of his rights, okay, that the article confers on him either at the time he is arrested or at least before he makes a statement in front of the investigative authorities or any other authority of the concerned state, okay, which has detained or arrested him. Okay, so in order to be reasonable within in order to be reasonable, in order to come within the scope of the term without delay, the concerned individual has to be informed either at the time of his arrest, means as soon as he arrested, or before he makes a statement. Of course, this is the minimum. Okay, that before he makes the statement. Why? Because if otherwise he is not informed of his right that he can have consular assistance, or etc. He's not provided any legal guidance. He has, he's not able to consult any lawyer or anybody. Then, the meaning of this right, if he is informed after he has made his statement, okay, it's lost. Okay, so the right will no longer be useful. Okay, it will be useless. So therefore, the individual has to be informed either at the time of his arrest or before he makes his statement before the authorities. Okay. Now, going further, the court it interpreted the court dealt with the interrelationship between different human rights instruments. Okay, so it said that Article 260, Article 2, 6, 14, and 50 of the ICCPR, that is uh, the Covenant on Civil and Political Rights. Okay, it concerns the protection of human rights in American states. Why? Because the ICCPR is applicable on every state, okay, which is a party to it, and it provides a right to all the individuals concerned. Okay, so therefore, the rights that have been given under Article 2, 6, 14, and 50 of ICCPR, they are also meant to be enjoyed, okay, by the people in American states, and therefore they are also concerned with the protection of human rights in the American states. Okay, because they are also applicable to the American states. Now, the court, it said that the individual's right to information established in Article 36(1)(b) of the Vienna Convention on Consular Relation allows the right to the due process of law recognized in Article 14 of the ICCPR to have practical effects in concrete cases. This means that the court here is telling that, the right that the individual has to be informed. Okay, that right which has been given under the Vienna Convention, okay, it recognizes the right of due process. Okay, the right to the due process of law that has been recognized in Article 14 of ICCPR. Okay, and Article 36 1B of the Vienna Convention, it gives effect to this right to due process of law, which is contained in ICCPR. Okay. Now, it also said that Article 14 establishes minimum guarantees that can be amplified in the light of other international instruments, such as the Vienna Convention on the Consular Relations, which expand the scope of the protection to the accused. Now, Article 14, which deals with the due process of law, okay, the right to the due process of law, it is the minimum guarantees, okay, that the states are obliged to provide, okay, and the states are obliged to respect. Okay, it is the minimum guarantees that every individual is having, okay, as per the ICCPR. Now, the states are under an obligation not to violate these minimum guarantees. Okay, every individual has at least this these rights. Okay, but the states, they are always free to provide more extensive, protection to the individuals or to the peoples. Okay, so that can always be done by the states, but they cannot, minimize the content of the rights, okay, as has been given under Article 14. So the minimum guarantees that have been given under Article 14, they have to be respected and they have to be provided to all individuals. But the states or, the conventions, they are always free to give additional rights, okay, additional guarantees, a better protection to the individuals concerned. Okay, which the Vienna Convention on Consular Relation, it gives, it expands the scope of these minimum guarantees that have been given under Article 14. So it in effect gives, you know, expands the guarantees, okay, expands the protection that the concerned individual is having, okay, and therefore gives, enlarges the scope of the protection. Now, the court, it also said that the failure to observe a foreign national's right to information, okay, is prejudicial to the due process of law, and in such circumstances imposes uh, imposition of death penalty is a violation of the right not to be deprived of life arbitrarily. Okay, so every person has a right that he should not be deprived of his life and liberty except by the due process of law. In our constitution, we have the procedure established by law, which, after the interpretation of the Supreme Court, I've already told you, it came more close to the same interpretation as due process of law. So if that if the due process of law is not followed, it will amount to arbitrariness. And in this case, if a state has failed to observe you know the mandate of article 36 1b of the Vienna Convention, then it can be said that the imposition of death penalty, which was the punishment that was being given in this case, okay, or any other punishment, it will be a violation of the person's, okay, violation of the person's right not to be deprived of his life and liberty in an arbitrary manner. Okay, and this, according to the court, will have you know the consequences of the state, okay, which is violating the rights of the individual in this manner, okay, of incurring international responsibility, because the right, it forms part of the international law. So the state concerned, if it acts in such an arbitrary manner, okay, it will be incurring international responsibility. Now, the court, it also held that the international provisions that concern the protection of human rights in the American states, including the right recognized in Article 36 1b of the Vienna Convention on Consular Relations, must be respected regardless of whether there is a federal or unitary structure. So, what happened? What the court is telling us that you know the mandate of the convention. Okay, the mandate of the convention, it has to be respected, okay, and it will not be a justification to derogate from the mandate of the convention, okay, or violate the mandate of the convention by taking an excuse of the domestic position, okay, or domestic concerns of a particular state. For example, it cannot be said, suppose state X, okay, is there. In this case, America was there. We take the case of America only. In this case, America was there, USA, okay, that means United States of America. So the United States of America, okay, it is a federal country, okay, and the states there, they have their own criminal laws, okay, which carry their own penal provisions, and the penal provisions and the procedures, it differs from state to state. Okay, so in this case, uh, America, the United States of America, it cannot say that, you know, because this is not, they cannot help in this regard, because the death penalty, okay, has been, you know, afforded by, the death penalty has been imposed by the federal states, okay, according to their own, uh, you know, according to their own laws, penal laws and procedures. Okay, and this United States of America is helpless in this case. Okay, it cannot force its uh, states. Okay, for example, the state of Alabama, or the state of Texas, or any state that is concerned. Okay, it cannot force these states to to violate their laws, or not to execute a person in consonance with their laws. So this domestic situation that is that the American authorities might be facing, this cannot be or just excuse or justification. It cannot work when it comes to the uh, when it comes to the obligations. Okay, when it comes to the point of abiding by the obligations that have been given under the convention. Okay, so that mandate of the convention, it has to be respected, okay, regardless of the state's domestic issues or problems. Okay, now the second case that we have before us is the case of international responsibility for the promulgation and enforcement of laws in violation of Articles 1 and 2 of the American Convention on Human Rights. Okay, so this case it was concerned with Article 1 and the violation of Article 1 and 2 of the American Convention. And Article 1 we know is, the non-discriminatory provision that has been incorporated in the convention. It says that the state parties have undertaken to respect the rights and freedoms recognized in the convention and to ensure all persons subject to their jurisdiction, okay, the free and full exercise of those rights and freedoms without any discrimination. So this Article 1, it obliges the state to provide everybody with the full free and full exercise of the rights and freedoms given under the convention, okay, without any discrimination. Okay, and Article 2, it basically says that uh, where the measures concerning or giving effect to the freedoms, to the rights and freedoms that have been incorporated in the convention, okay, uh, they do not exist in the domestic law of the state, okay, or in that state where the rights and freedoms have not been given effect, uh, in the state, then the state parties will adopt suitable legislative or other measures to give effect to the rights and freedoms given in the convention. Now, in this advisory opinion, okay, this advisory opinion, by the way, was requested by the American Commission on Human Rights. As we already have seen that the advisory jurisdiction, uh, it not only confers power on the or empowers the states, okay, to request an advisory opinion from the court, but it also empowers the organs of the Organization of American States to request an advisory opinion. So therefore, uh, this advisory opinion was requested by the American Commission on Human Rights. Okay, and in this case, the American Commission on Human, in this case, the American Court of Human Rights, it told that where a law which is promulgated in a domestic, a law which is promulgated in a state, okay, means which forms part of the domestic law, okay, of a state, if it is manifestly in conflict with the obligations, okay, under the convention, then that law will be violating the mandate of the treaty, and therefore that state, okay, which has promulgated such a law, which has enacted such a legislation, it will be violating the treaty, okay, and the violation of the treaty will incur international responsibility, okay. And but what is of special significance in this case was that the court is not talking only about international responsibility for the state, which of course, if a treaty is violated, okay, it generally crops up, okay, the question of international responsibility for the state. But in this case, it goes a step further, okay, and says that it will also, you know uh, incur responsibility, okay, on the officials who execute that law. So the officials or the agents of the state concerned, okay, who are executing that particular law, okay, they will also incur responsibility. So here the court is not talking about the state's responsibility, but it is talking about individual responsibility. So it is telling that the violation of the treaty, it can give rise to both international the state's responsibility as well as the as individual responsibility. Okay, and this is significant because generally individual responsibility is, you know, does not find such um, except in certain circumstances. Okay, it's not individual responsibility does not find a place under international law. Okay, so only under international criminal law, for example, if genocide is there or crimes against humanity is there, individual responsibility can arise in those cases. But otherwise, you know, if we talk in general, then uh, under international law, it's only the state responsibility that arises and not individual responsibility. But in this case, the court has also talked about individual responsibility. Okay, if a state violates the mandate of the treaty. Now we come to a comparison between the European Convention on Human Rights and the American Convention of Human Rights. Okay, and we see that they both are when we were doing the American Convention, because we have already done the European Convention on Human Rights. Okay, after a study of the American Convention, we can come to the conclusion that they are both similar in certain aspects as well as different in certain aspects. Okay, so the similarities between both the conventions, the points of similarities are first that, both the conventions, they only incorporate civil and political rights. So the European Convention, when we were doing, we studied that it only talks about civil and political rights, okay, and did not talk about economic, social, and cultural rights. But for that, it has, for this purpose only, it had made a social charter. Okay, uh, so there is a charter which deals with the economic, social, and cultural rights that the European states, okay, they entered into, which talks about economic, social, and cultural rights. And the American Convention, it is also restricted to only civil and political rights. But then there was a American Declaration which talked about economic, social, and cultural rights also. Okay. The next is that both of them, they oblige the state parties to achieve progressively the full realization of the rights. Okay, so we when we were doing the American Convention and when we studied the European Convention, we found the same wordings. Okay, they both mandate, they both mandate the state parties to the convention, okay, to the respective conventions, that the state party should endeavor to and work to progressively realize the rights, okay, that have been given under the convention. Now, the third point of similarity is that they both contain a broad non-discrimination provision. Okay, that means both of them, they mandate that the rights under the convention, okay, the state parties have to ensure the rights and freedoms under the that have been given under the respective conventions based on the principle of non-discrimination. Okay, so both of them have they contain a broad non-discrimination provision. American Convention of Human Rights, just now we saw Article 1, it is the non-discrimination provision under the American Convention of Human Rights. Okay. Now both the conventions, they also permit derogation. Okay. For example, when there is a situation of emergency, or an you know or a situation which threatens the life of the nation itself, or which poses a danger to the stability and security of the state, then the states can invoke uh, the provision that will allow them to derogate from the obligations under the convention. Okay, so both of them, they allow in certain cases to they allow the state parties concerned to derogate from the obligations of the convention in certain cases. Okay, now we also find that in both the conventions, okay, when we come to the court's contentious jurisdiction, the contentious jurisdiction is final and is not subject to appeal. So, just when we did the American Court of Human Rights, okay, the contentious jurisdiction, when we were dealing with the contentious jurisdiction of the American Court of Human Rights, we found that there is no appeal against the judgment of the American Court of Human Rights. Okay, it's the same with the judgment of the Grand Chamber of the European Court of Human Rights. Okay, and under both the conventions, the court lacks the power to enforce its judgments and preliminary rulings. So, when we were doing with the European Convention of Human Rights, we came to know that the Committee of Ministers under the European Convention, it is responsible to execute and see to the enforcement of the rulings of the court. Okay, and under the American Convention on Human Rights, okay, it is the General Assembly of the Organization of American State which sees for the sees to the fact that the decision of the court, American Court of Human Rights, it is executed and enforced. Okay, so under the European Court, under the European Convention, the European Court, it relies on the Council of Ministers, while in the American Convention, the American Court relies on the General Assembly of the Organization of American States to execute or to enforce its rulings and decisions. Now, the differences in both the conventions, we come to the differences between both the conventions. Okay, and the first difference that we find, okay, is that the American Convention, it talks about both the rights as well as the duties of the individual. Okay, while the European Convention talks only about rights and not the duties. For example, Article 32 of the American Convention on Human Rights. Okay, it talks about relationship between duties and rights. And the first para of Article 32, it says that every person has responsibilities to his family, his community, and mankind. So this article is talking about the duties also. Now, the next point of difference is that while the European Convention has a mandatory interstate complaint system, such a system is optional under the American Convention. So, American Convention, we already under the American Convention, we already knew that when we studied the American Convention, we already know that uh, a declaration has to be made by the state. Okay, only then it this commission will be or the court will be able to hear or receive and examine a complaint against that state. Okay, so under the American Convention it is optional, but this is not the case under the European Convention. Now, the next difference that we have between both of the conventions uh, is regarding the point of individual applications. Okay, so we find under the European Convention that the European Court of Human Rights, it can consider individual applications. Okay, but the American Court of Human Rights, it cannot consider individual applications. Okay, the application to the court, it has to come by way of commission. Okay, or by the through the states. Individuals cannot directly submit applications to the American Court of Human Rights. Okay, the next is that in both the systems, the court has advisory as well as contentious jurisdiction. But European court's advisory jurisdiction is much more constricted. Okay, we just now we have studied the advisory jurisdiction of the American court, and now we know that the advisory jurisdiction of the American court is unique. Okay, because the member states, it's not restricted only to the member states, but also the organs of the Organization of the American States, they are also empowered to request a advisory opinion from the court. And then it is not restricted only to the interpretation of the provisions of the convention or the working of the convention, but they can also request both the states and the states. They can also request uh, an advisory opinion, okay, on any other international human rights treaty or instrument, okay, to which they are a party. Now, with this, we have covered our American Convention on Human Rights. Okay, and if there is any problem, you can always write back to me. I keep on repeating time and again. Okay, and I hope that you will sincerely study law of human rights. Okay, so until the next session, take care. And in the next session, we will be dealing with the uh, protocols of the American Convention of Human Rights. Okay, thank you.